Iminat 32 na Legislature ng Guam is called to order. Senator Respicio, you are recognized, Mr. Majority Leader.
Thank you very much, Madam Speaker. Madam Speaker, I believe at the time we recessed, we were on the matter where you ruled on the germaneness of the amendment to Bill 19, and so I believe that's where we would pick up the discussion right at this moment.
But I think before that, because we've made some attempts, if a motion could be made to please excuse Speaker Pangolin.
Oh, certainly, ma'am. I move that, but we're not voting yet.
I
so,
know we're not,
yeah.
but
Well, for
just
the
for purposes of the fact that we have 14 members present this morning.
okay, yeah, certainly. So I move that Speaker Pangilinan be excused for session.
Thank you. So my dear colleagues, before I think we begin, I'd just like to thank each of you for being here today. And as I've stated this morning, I'd like to reiterate for the record is that every day I know our people wake up and they feed their families, go to work, and do it all over again. They want to know that those elected to govern will dispense their duties and get to work. And I'm here in this spirit, and I know each of you are here in that spirit as well. We all love Guam and want to see it better. This is where we must begin, and where I believe we will end. When I sit as speaker, I set aside personal thoughts on any subject. Every procedural decision I make is based on a fair application of the rules and laws that govern our legislature. In spite of all our passions, all of our deeply held beliefs, the legislative process exists by the rule of the law, the rule of the majority, and the protection of the minority through rights that can never be ignored. It is not about dueling press releases or calls to session. It is not about who sits in the speaker's chair or who is right or wrong. I began the 32nd Guam Legislature stating in my inaugural address that my job was to embrace my colleagues in all branches of our government as family, to respect and accept them, to work together, always keeping in mind the people of Guam in our hearts and minds. I remain committed to that challenge. We've got a lot of problems to work out, and living as a member of this family will not be easy. You will experience sibling rivalry, and you may get hurt along the way. But remember that no matter what happens in this house, we only move forward when we move together. This sort of thing takes work. Good families don't just happen. They require extra effort, sincere compassion, and most importantly, they require good communication. We are all here for the same reason. We're all fighting for the same island and the same people. We just have different ways of seeing things. I believe that through dialogue, we can learn to understand each other. Then we can find a way to create harmony and unity in our government. Dialogue would allow us to find a shared vision for Guam that would move us into the next millennium. I believe that today, as I did just months ago. Thank Thank you very much.
Point of personal privilege, Madam Speaker.
Yes, Senator.
God bless you, Madam Speaker, and God bless Guam.
Thank you. We left off, if I can remember correctly, and I'm going to ask the clerk if you can please, I know that we had Senator Frank Uggan request that the the author of Bill 19 be allowed to speak on the amendment. And I think that that's where we left off with Senator Dueñas. So Senator, you are recognized. Okay. So, okay, yes. It's on the amendment, and that's where, yes, we are on Senator Rodriguez's amendment, which was to make an amendment to place Bill 20 as an amendment to Bill 19.
And point of order, Madam Speaker?
Yes,
Can
please
the
state your
clerk
point of
just,
order.
thank you, can the clerk just recap those senators that spoke on the amendment?
Do you want, I'm going to ask the clerk to go ahead and, which one? Yeah, no, go ahead.
Point of information, Madam Speaker, I'm just going to go ahead and say what I recall rising
No,
to
no, it's
the
okay.
objection. Yeah.
Oh, okay. I mean, I had conferred with the clerk, and basically what she said, when the motion was made by Senator Rodriguez with the amendment, there was a call, of course, for the germaneness of it, and then I had, ruled on the motion. Then what had happened was then a vote was called, and the overruling had prevailed, and then that's when Senator Uggan stood up and then basically said that since it was Bill 19, that the author should be given, the opportunity to state whether he, is in favor of it or objects to the amendment being placed on Bill 19. And if I understand correctly, Senator Dueñas, that you had objected to it being placed. So the discussion is the acceptance of that amendment now for discussion. Is that everybody's understanding? So on that motion, the amendment, the Rodriguez amendment, then the primary sponsor of the bill itself had objected. So it's open now for members to basically state, your opinion, whether you are for or against the amendment. And I did not have, from my notes, I didn't have anybody else on the list other than Senator Dueñas, so Vice Speaker.
Madam Speaker, I won't go on ad nauseum repeating myself. I object to the amendment, and I oppose it at the same time. I rise in opposition.
Is there anybody else who would like to? Senator San Nicolas and then Senator Uggan.
Thank you, Madam Speaker. Madam Speaker, I'd like to take the opportunity to recap what has brought us to this point with this amendment? Right now, the entire issue has been framed in such a light that anybody who votes in favor of this action, whether as a standalone bill or as an amendment, is in favor of gambling. And that is not only overly simplistic, but I also believe completely erroneous. What we have right now, Madam Speaker, are machines that have been relicensed and are operating on this island, and they're paying taxes. Now, there are those who say that if we were to do anything to raise the taxes on these machines, which is what the amendment intends to do, or raise the fees on these machines, which is what the amendment intends to do, that we are thereafter legalizing these machines. But Madam Speaker, I have made the argument before, and I stand behind the argument again today, that just because somebody pays taxes on something doesn't mean that it's legal. Even the IRS requires you to pay taxes on illegal activity. It's one of the reasons why Al Capone went to jail. There are Supreme Court cases where individuals did not declare income on their income tax return because they felt that it was violating their Fifth Amendment rights and incriminating them because they had earned that income illegally. And the Supreme Court has ruled that you report all income, regardless of the sources of that income. So just because something is taxed doesn't mean that it's more or less legal. And this amendment does not speak to the legalization of anything. It speaks strictly to the question of whether or not we're going to raise taxes on these devices and direct those taxes to our hospital. Now, the alternative is to do nothing. And if we do nothing, those machines will still continue to operate, and they'll be operating at a lower tax rate. So do we do nothing and let them keep operating at a lower tax rate? Or do we tax them more and get that money to the hospital? That is what this amendment seeks to clarify, Madam Speaker. And I'd like to also recap why we're here and why there's so much confusion. Strangely and sadly, some members of this body have gone out and spoken and said that this bill will legalize gambling. We have put ourselves and painted ourselves into a corner, defining something that has not even been defined in the courts. And what's even more sad, Madam Speaker, is that we're not the ones that license these devices. We are not the ones that relicense these devices. We are not the ones that are ignoring the Attorney General and putting these things back on the streets. All of the activities that have brought these devices back into our community are as a result of the actions of the administration. With but one phone call, Madam Speaker, the governor can call the Director of Revenue Tax and tell him to revoke those licenses because they are issued in contravention to Guam law. With but one phone call, the governor can pull those devices off the streets and put an end to this entire question. With but one phone call, this whole question of gambling and gaming can be put to rest if the governor will just make that one phone call. But he does not, Madam Speaker. On the contrary, his director has not only licensed these machines once, but has relicensed these machines. And for some strange reason, we have allowed ourselves to all of a sudden become the center of attention over whether or not we're going to allow gambling in this community. That is not a question that we have decided, and it is neither a question that we're going to further clarify. Plain and simple, the administration has allowed these devices back into our community, and we, as a body, not only have no control over that because that is an executive branch function, but we now must ask ourselves, If these devices are going to be in our community, are we going to tax them more and send the money to the hospital or not? And that is all that this amendment seeks to do. So if anybody wants to say anything about ending gaming or gambling or anything about these machines and putting them out of business and taking them off the streets, pick up the phone and call your governor. Because the executive branch has been and continues to be the one and only reason why these machines are in operation today. Now, Madam Speaker, shall we do our job and regulate these machines? Shall we do our job and tax these machines? Or are we going to just do nothing and allow them to continue operating at a lower tax rate and not send that money to the hospital? That is the question before us today. And some have turned this into whether or not we support gambling, perhaps to win favor from groups in this community and turn themselves into champions of a cause at our expense, at the expense of this body. But that is not the question before us today, Madam Speaker. That question has been asked and answered and re-answered by this administration. And if the Attorney General wants to get those machines off the street, then he needs to get them off the street. He could have filed an injunction to prevent those machines from being relicensed. He didn't even do that. So many other avenues could have been taken to take these machines off the streets, and they weren't taken, and they were not within our realm of control. And again, it just takes one phone call by the governor right now. If he picks up the phone and calls the director can revoke those licenses. So the people of Guam should await that phone call or draw the only logical conclusion that the administration supports these machines, and that if these machines are in fact gambling, then the administration supports gambling. And now, the question that we have to ask ourselves is, if something is duly licensed and operating on this island, shall we regulate and tax it? And that, Madam Speaker, is why I support this amendment. I was the one the other day who introduced the amendment to remove all gambling, all gaming. Let's take it out. And I voted for that amendment, and that amendment failed. And so this body made a very clear statement that there will be some activities on this island that we will regulate and tax these activities. And so if there are any legal activities, legal in the sense that they have all the necessary elements to operate, then let us regulate and tax them. And that is what this amendment does. And let us not tear our own selves apart over who supports gambling or not, because that is not even the issue before us. And there is only one person who can answer that question, and that is our governor, because he was the one, and his director is the one, who has issued the licenses and can revoke the licenses. Let him answer the question. And let us do our job, regulate and tax these devices. And while we're at it, let's get some money to the hospital, because they desperately need it. Thank you, Madam Speaker.
You're welcome, Senator. On the amendment, Senator Limtiaco.
Thank you, Madam Speaker. Madam Speaker, I'd just like to speak briefly and refer back to my what I said on the main motion. And I'm going to read from you, real briefly, our current law as it establishes the definition of gambling. And once again, 9 GCA Chapter 64. This is our current law. Gambling as defined and punished, except otherwise prohibited by this chapter, and this one sentence here is part of the problem, but going on to further describe it, makes or accepts a wager involving money or anything of monetary value upon the result of any game or contest, holds any money or anything of monetary value, which means a prize, which he knows has been wagered in violation of paragraph 1, or sets up, promotes any lottery, or sells or buys any lottery ticket. And Madam Speaker, why that definition is so important is because this whole issue as to whether Bill 20 and the amendment to Bill 19 is going to legalize gambling, I want to make it very clear to our listeners and to our public that we already allow gambling. We do it. Our community accepts it. Not that it's right, but that there's inconsistency in the law. We allow for a lottery. We allow for bingo, which is winning a prize, whether you win it for money or you win a prize, which is a monetary value. Or you go up and you put $1 on the pay red at our carnival, which is supposed to be a family affair and to celebrate our liberation. And you just walk over to the full-blown casino, which accepts wagers on any form of gambling, whether it be baccarat or any kind of games of cards. And why this is important is because, once again, we need to take the blinders off. We can't get up here and start talking about that any one particular form of gambling is legalizing gambling, because it's already being done, and we need to address it. And what I've argued this entire time is that when we talk about the initiatives, take the last two, for example, Proposition A and Proposal A, and they say our community has spoken on gambling, and they've had a resounding no. I want to be very clear. What they had a resounding no to was for those specific proposals and propositions, most of which always had the licensing go to one individual or company. Now you take that in its context and you look at what we allow now. And what we allow now is, and what we allow right now is for the Mayor's Council to do it, for GNOC to do it, for the Pangolin bingos to do it, and at one point in time for our church to do it, which I know they no longer do it now. But that's what I'm getting at, is that we finally have put the question in front of the body. And although it was addressed in an amendment to Bill 19, those that voted no on that amendment didn't necessarily vote to legalize gambling. What they took into consideration was the effect of what that had on the bill. You took a bill that was going to tax nonprofit organizations, and you basically told them that what you showed up and what you were noticed for in the public, and what we had a public hearing on how this bill would affect you, which would have been to tax your operation, and took that bill and basically said your main source of revenue now for your operation will no longer cease to exist. That's irresponsible. We have no way to wind down those nonprofit. There was no part of that amendment that said, given a certain time, you can't do this anymore. How responsible was that? How many of those nonprofits provide community services to our public that our government just can't do, or just doesn't, or chooses not to do? So voting no on that amendment wasn't to legalize gambling. It was to take the big picture into consideration. That yes, this issue needs to be addressed, but not in an amendment. Notice the public, have a public hearing, bring it to the people in the form of an initiative. Should we continue to allow a full-blown casino at our Liberation Carnival? Should we allow for bingos to happen at our community centers? Should we allow for cockfighting and gambling at our fiestas? That's the big picture. But until that happens, until we all agree to bring it before the people, and if nobody here wants to do it, I'll proffer the initiative myself after this session. But but until we do that, we need to remain consistent that the lottery and the bingo that Bill 19 chooses to address and tax, look at the underlying factor. These, as defined by 9 GCA Chapter 64, is a form of gambling. These symbolics machines, they're a form of gambling. They're the same thing. And if we're going to continue to let them operate, why shouldn't they be affected by these same bills? Why shouldn't they be taxed accordingly? And if you look at the amendment on page 3, it clearly shows that. It says that right there. It says, "Y Legislature in Guam finds that a variety of gaming and licensed gaming devices and activities are currently in existence and are operated legally and regularly in Guam, including devices that have been licensed twice by the current administration. Examples include lottery, casinos, Liberation Day festivities, cockfighting, pachinko, and bingo." And it should say these machines as well, but it says to name a few and others. Then you go to page 14 of the amendment, which is also an addition to what Bill 20 did not originally have. And it says the rules and regulations. And it says within 180 days of impaneling of the Guam Gaming Commission, the commission shall develop rules and regulations providing a fee schedule for the assessment of across-the-board fees for all gaming activities taking place in Guam and consistent with existing rules and regulations and this act. Such new rules and regulations shall also be consistent with the manner in which existing gaming devices have been legally authorized pursuant to Title 11. Such rules and regulations shall also be consistent in the manner in which other gaming devices are taxed. So what this bill does is says, it finally takes the blinders off and says, if we're going to allow for this, let's acknowledge it and let's tax them all. And until an initiative that comes before the people that specifically talks about all these things that we allow, that as defined under our law are also forms of gambling, then we should tax them. That's what this bill is saying. They're no different. Anybody that would argue that Bill 20 or this amendment to Bill 19 is legalizing gambling has the blinders on, and that's what I'm trying to say. If we want to address the gambling, the initiative as a whole, let's notice the public. Let's bring them all in for a public hearing. Let's put it on the ballot. Let them decide. But until then, we should be consistent. We shouldn't ignore the underlying fact, the underlying definition as provided our law as to how it applies. We shouldn't just pick and choose which one is right or wrong. That's wrong. Madam Speaker, it's not about legalizing gambling. These machines are already licensed. That doesn't make it right. My argument, and I'll remain consistent on it, my argument is that let's call it a spade a spade. If it falls under the definition of our own existing laws, whether it's for a non-profit or a for-profit, it's the same thing. And let's stop all hiding behind whether or not this bill is going to, or this amendment is going to legalize gambling, because we already are allowing gambling. This community hasn't spoken on whether it approves of the Liberation Day casino. It hasn't spoken on whether it approves of the bingos. It hasn't spoken on all of those forms of games of chance, which as defined in many dictionaries, whether it's in our own code or online or Webster's, they're all games of chance. And under games of chance, it's considered gambling. Now we get our laws all get wrapped up into this distinction between games of skill and games of chance. And once again, as defined, what we currently allow for are games of chance, especially with a full-blown casino at our Liberation every year. So let's be consistent, and if we're going to just look at the bottom line as to whether these are games of chance and are considered gambling, whether they're allowed by law or not, or legally licensed or not, we need to remain consistent. And then after we do this, let's take it to the people. Let's put it all on the line, but at least properly notice our public, give them the opportunity to attend the public hearing, and then put it on the ballot. Thank you, Madam Speaker.
You're welcome, Senator.
I rise to a point of order.
Please state your point of order.
Thank you very much, Madam Speaker. Madam Speaker, I present that this session has not complied with the laws of Guam with regards to its call. The session is required to be called by the sitting speaker of the legislature, that it requires a 2-hour notice in pursuant to the open government law, And I know I received a call for session at 1 p.m. I did not, from the Speaker's office. I did not see a call for a 9 a.m. session from the Speaker's office. And even if the Speaker's office called for a session that open government requires a 2-hour notice, while we may be able to waive all of our rules, we cannot waive law, Madam Speaker, and therefore I object to this session and request that the Speaker rule on whether or not this session meets the requirements of law.
Point of order, Madam Speaker.
Please state your point of order.
Madam Speaker, while I certainly respect the previous speakers many years in this session, I also want to call to your attention in the body session is that I sent a response to your calls to a session at 1 p.m. where twice you said that there's a question of the legitimacy of that session. And so, Madam Speaker, I rise to point out that when we were in session on Saturday, your motion to recess for July 1st, Madam Speaker, that went from a motion to recess sua sponte for periods deemed appropriate to a motion to recess to a time to return. And when I objected and several members objected,
That was not a
that's
motion, Madam
debatable
Speaker.
motion.
That was an action taken by the Speaker authorized in our rule. It was not a motion to recess until a time
Madam
certain.
Speaker, may I be
So-
permitted to continue without being interrupted?
Proceed.
Thank you very much, Madam Speaker. Madam Speaker, we know that the rules say that the Speaker as or the presiding officer can recess the legislature for periods deemed appropriate. We also know that this means when you recognize that several senators have to get together to work on the amendment, you say, I move for a minute recess, I move for recess for lunch, I move for recess to the following day. And these are all motions to recess to periods deemed appropriate. Now, once you said that you recess for a period, that you recess until July 1st, that is now a motion to recess to a time to return. That under our rules, and the previous speaker can take a look at the rules. Now that under our rules becomes a motion to recess to a time to return, and then that now becomes a motion that's debatable. There was an objection. If there was no objection, Madam Speaker, certainly it would have been in your right to recess us till July 1st. There was an objection that was raised before the gavel was made. I raised the objection. You didn't recognize my objection. And so instead, what happened was after you left your chair, 9 of us stayed back, and 9 of us feel that we clearly have the majority and the will of the majority. As you said this morning in your public address, that we are a rule of law. And so since the majority of us felt that what you did as presiding officer was not pursuant to our rules, that same evening, Senator Barnes reconvened that session, Madam Speaker, and she recognized that an objection existed. There was a vote taken. Not a single member that stayed wanted to agree with your motion to recess till July 1st. And so then the next motion was to recess until Monday at 9 a.m., which the proper public notices were given immediately after we recessed on Saturday. And so it's not a matter of giving a 2-hour notice based on your 1 p.m. call. This is a matter of recognizing that what we're in today is a continuation of the session that we were in on Saturday. And you motioned us, and you should have recognized someone to make a motion to recess until July 1st, but unfortunately you did not. You tried to do that sua sponte. Whoever's giving you advice is giving you bad advice, Madam Speaker. I'm not afraid to say that publicly. You motioned us, you attempted to motion us sua sponte to July 1st, which now means it's a motion to recess to a time certain, which under our rules is debatable.
Madam Speaker, if you'll review the rules, it doesn't say that the Speaker by motion can recess sua sponte. So I would request then that we recess for 10 minutes while you decide on the question of whether or not, again, the call for this session
Another
meets the
procedural
law.
attempt, Madam
Senators.
Speaker, to thwart the will of the majority.
Will the 3 of you please take your seats? Somehow, I know in the statement that I've made this morning, that we're not here to prove who's right or wrong. And you're all right, and you're all wrong. In the sense that, yes, a motion is normally made from the floor, similar to what Speaker Pangolin has requested for a recess. It's not debatable. The time is. The Speaker can recess sua sponte on my own without even a motion on the floor. But we were going down the path that is surely not going to take us where we need to be, and that is to continue with the work of the people. So by coming in this morning and presiding at this morning's session, we will proceed.
Thank you, Madam Speaker. Thank
Once
you.
again, I rise to the. It's,
Yeah,
it's,
okay.
it-
So
Madam
there
Speaker,
is, okay, so you're going to motion a separate motion now for a recess. And I understand that, and procedurally, yes.
Madam
can
Speaker, I'm
recess.
asking for a ruling of the chair with regards to the law that requires open government and notice.
Point of
for
order,
the-
Madam
for the
Speaker. Why do
meeting.
you allow him to keep
And-
putting you on the
Senators,
spot? You made your
please.
point. You ruled.
Yes, I realize that.
Point of
But then at
And
the
I
information,
same
think he's
time-
being,
Madam
Ma-
Speaker, I have a point of information concerning our Masons rules.
I'm
Chapter-
referring
chapter
to Guam
24,
law,
chapter
open government,
24.
Madam Speaker, and who can call this legislature into session. I'm not referring to rule. I'm referring to the law that requires
Madam
legitimacy
Speaker, this
Senators,
is-
of this
this
body.
we are going
this-
to
thank you.
take a brief recess.
but this is not a new call to.
We're going to recess. the legislature's back in session. And we left off, of course, of disagreements on the open government law. And I realized that there are differences of opinion, just as much as you get 9 lawyers in a room and you get 9 different opinions. And here as lawmakers, we all have our opinions as well. And there's the question, yes, of rules. There's the question of law. There will be a question on our actions, and the question also in terms of the legality of any action that we've taken today. And in this spirit of working together and not getting us down that path where we're going to continue to dig our feet so deep that we won't be able to repair what is happening here in this house. And it's out of my hands in the sense that any settling or interpretation of any action that we would take at the very end of this session will be in the hands of those who basically does the interpretation. Now the announcement that was made Saturday evening, with whom you've appointed to be your presiding officer at the time, versus the fact that the Speaker and the Vice Speaker were on island Saturday evening, and the question of reaching either one of us also can be argued. This is an unfortunate case, of course, in which anyone could have a field day with what actually has happened. But we need to continue with the work of the people. And that's how I like to see this happen. And any one of you have the right to challenge, of course, my decision, to challenge the actions of this body as a whole beyond this house. And yes, I could decide whether one is to recess, to allow for the full 2 hours. We could also continue, and I know in my announcement at 7:40 this morning, publicly, and statement being sent out to all the public and printed media, and starting earlier, shy of 15 to 20 minutes of that 2-hour time frame, could be questionable. And I know we always say that in the past, and that we have actually started even earlier, by even 5-10 minutes, but that wasn't even questioned at all then. And whatever the motivation or the drive is that I, again, would like for us to proceed. I know I can be overruled again. But I will make the decision that we will proceed.
Madam Speaker, thank you very much. I just want to state for the record, though, that the decision to preside over the hearing this morning is completely different from a action of a call to session, and then, of course, continue to state for the record that the conducting of the session, while we may waive our rules, we cannot waive and are unable to waive our laws, and therefore I continue to place on the record that this meeting of this legislature is inconsistent with the laws of Guam.
Thank you very much. And yes, your statement, of course, is definitely going to be a part of this journal.
And
Majority Leader.
thank you, Madam Speaker. I'd like to also state for the record that your call to session for 1 p.m. is very different from this continuation of the current recess that we're in. If it satisfies the previous speaker, at 1 p.m., rather, you can do your call to session and then we can adjourn immediately. That's a separate matter. What I've been able to articulate, and I thank you for your ruling, is that our reconvening of 9 a.m. is a continuation of our session that we were in on Saturday. And so I'd like to state that for the record, and I appreciate your leadership in wanting to continue to move us forward and to have your actions as chair represent the will of the majority.
Thank you very much, Madam Speaker. I certainly recognize the majority leader, but that is exactly my point. The call for the 9 a.m. session is inconsistent with the laws of Guam with regards to who can call session and the notice required for session to be called. The standing rules in both the laws of Guam, so I'm just saying that that call to continue the session, which has been recessed pursuant to the rules and the laws of Guam, are inconsistent with the continuation of this session.
Yes. Senator Tom Maddow, you're recognized.
Madam Speaker, I recognize the forte of the two speakers and their adeptness in parliamentary procedures and all that. But the way I see it is that we are not into a new session here. We are continuing a session which was abruptly interrupted on Saturday evening. Regardless, we've been here for an hour and 40 minutes, going back and forth, back and forth. Now, you've made the ruling that we are going to move forward and we are going to dispose of the bills that we have debated, and we've got 2 more bills on the floor. And I just ask, let's move forward and get that work accomplished. And all this maneuvering and whatever you want to call it, it's just not getting us anywhere. And I'm really starting to, it's very frustrating. This almost, I'm not even gonna go there, but I wish you've made a ruling, and if the majority did not agree with that, then they certainly have the prerogative of objecting and calling for the vote to overrule, but that's not the case. At least I haven't heard an objection, but I want to move forward, and I think there are a number of other senators who want to move forward, and let's get this session completed and move on, because we have also other work that's still waiting. Thank you.
Madam Speaker, God forbid that the Organic Act and the laws of Guam get in the way of doing what we want to do.
Senator, I understand, and understand, of course.
Point of personal privilege, Madam Speaker. First, I'm being called a gambler when I'm not, and now I'm being called a lawbreaker when I'm not.
Senator, your
The individual isn't even an attorney, and he's going around defining what the laws of Guam are now.
I think, in our rules with personal privilege is that we do not, of course, personally attack anyone in here. And in the legislative process, very early on in our standing rules and Mason's rules, is that when we deliberate, we're speaking what we believe, what our values are, what our opinions are, and then we bring some facts and data to the table. That's what this deliberative body is all about. And I've allowed, of course, everyone, those who would like to deliberate on this, an opportunity to speak. But I think we're now, beyond that, and we will move forward. And as I stated earlier, and it is going to be part of the records, to move forward. And there's always, and no one can ever stop anyone, whether in this body or in the executive branch or out in the community, who would like to challenge, of course, the actions of this body with what we've done. And that would be at the ultimate end when we vote. And any attorney will tell us that. And that's exactly what I was told. And someone has told me there are like 9 attorneys out there. So I'm sure there are 9 different opinions. So we'll continue, and I know I have on the list is Senator Uggan.
Thank you very much, Madam Speaker, and good morning to you and our colleagues. Madam Speaker, I want to extend my objection to the amendment, and in particular, with due respect to the primary sponsor of the legislation, I think, and the sponsor of the amendment, I would think that both proposals should stand alone. I extend my objection to the amendment, and I move for the previous question with all due respect to our colleagues, Madam Speaker.
Yes.
Madam Speaker, I appeal to the body. I think we should be allowed to discuss this.
Okay,
I think
Madam
other
Speaker,
members
I
of this
withdraw my
body has-
motion.
Thank you, Senator, for withdrawing your motion. So those who would like to speak, I don't have anyone in the list. So if you do, okay, please raise your hand and let me know then that you would like to speak. So Speaker Pangolin, and you're recognized.
Speaker, if I may just move for just a 1-minute recess while I just gather a couple of documents here that I wanted to use during my talk.
We'll take a brief recess.
Madam Speaker, as much as we like to or not, and as much as my colleagues may object, I will give you what my opinion is on this amendment to Bill 20. In my opinion, Madam Speaker, this bill will legalize gambling, will legalize the gambling and the use of video machines for the purpose of gambling on Guam. They have been stopped from operating in our community over the last 5 years pursuant to a court case. And then all of a sudden, the court case was dropped and by the Attorney General in mutual consent with the owners of the machines and Revenue tax. The assurances that were granted, of course, is that because no law have changed, and because while during the challenge in the court over the last 5 years, the machines were not allowed to operate on Guam because presumably the court said they're illegal. So therefore, no machines can operate. What changed between the time that the lawsuit was dropped and the law? The law? Nothing. So if the machines were frozen for 5 years, pending a controversy in the court, they were frozen because the court said they're illegal, that they should not be operating pursuant to the laws of Guam, and until such time that the controversy is finally resolved in the court, they cannot operate. What changed, of course, is that when they agreed that they would drop the lawsuit and everything would remain status quo, meaning the laws would continue to govern then that these machines cannot operate, then therefore the laws would drop. What changed is the governor, in response to the request by the attorneys for the owners of these machines and his legal counsel, against the advice of the Attorney General of Guam, the lawyers for the Department of Revenue and Taxation then ordered the Director of Revenue and Taxation to issue the license contrary to the legal opinion and the position of the laws of Guam and the Attorney General. So, Madam Speaker, that's really what this is. If it is legal right now, and we're saying all we're doing is legitimizing it, then why are we changing the law? Why are we amending in the statute? If we say that the only thing we want to do in this bill is to tax the activity so that we can support GMH, why are we amending a section of the Guam Code that would legalize these machines, that have the effect of making something that is currently illegal under the Criminal Code of Guam and the statutes of Guam? Why are we having to amend a statute so that these machines can operate? If that is the case, then let us take out any reference at all to any law that's existing about gambling and about the use of these machines. Yet we have in here to amend so that we can ensure that they become legal. That's what this is. This distinction of trying to now, saying, oh my God, if they are legal...
Point of order,
then,
Madam Speaker.
Madam Speaker.
Point of order or point of information. I have information to refute the statements that are being made here. We have an Attorney General's opinion on this substitute version, Madam Speaker, that says clearly on his conclusion that these provisions, they are ambiguous and do not clearly indicate whether the name gaming devices will become legal.
Senator, I will
And this
give
is a document from the Attorney General.
Senator, when you close, you can provide that information in your deliberation
But the
as well.
misinformation must stop,
But Madam Speaker, I spoke...
Senator, like he said earlier, it is his opinion.
It is absolutely correct, Madam Speaker, that is my opinion and the opinion of the Attorney General. I spoke to the Attorney General and his staff, and they have said that this bill will absolutely and clearly make what is now illegal, legal, Madam Speaker. That is exactly what I am saying in my conversations with the Attorney General, Madam Speaker. And everybody else is free, of course, to present their conversations with the Attorney General. But those are the conversations that I've had with the Attorney General and the office and the attorneys in that office. It will clearly make it legal what is now illegal, what is now questionable in terms of its legality, Madam Speaker. Madam Speaker, these machines are licensed under amusement devices. So they become licensed under amusement devices, but under the Criminal Code of Guam, it's clearly stated in the statutes that these machines are illegal under the Criminal Code. So, Madam Speaker, the idea that we're going to just tax what is now a legal activity, I think is completely bogus. And that's, again, free for anyone to dispute that. And if you don't like it, then dispute it. But once again, Madam Speaker, this bill would make gambling by these video machines currently illegal, legal, Madam Speaker, and it is contrary to the wishes of our people. 5 times over the last 9 years, Madam Speaker, 5 times over the last 9 years, in no matter what kind of iteration it comes in. Madam Speaker, one of my colleagues said, well, the People voted no because they wanted to make it to be one operator, that it shall only be at the Greyhound. Well, that's what this bill does. It makes these machines and the operations of this machine one guy, one person. Well, I must qualify. I believe there's 200 and some machines, 216 or whatever, and 16 may belong to another person. But clearly designed to make it a monopoly, just as the people of Guam said, no monopolies on gambling as well. If we are really concerned, Madam Speaker, about the fact that we want to help the hospital, then why, and we want to do it through gambling, then shouldn't we take a look at how gambling then is operated in other jurisdictions and the type of tax that it has, Madam Speaker? Madam Speaker, the effective tax rate on gambling activities in other states and jurisdictions is almost 30%. We're only taxing these guys at 4%. If we really want to help the hospital and we want to help them fast and quick, then let's tax gambling how gambling is taxed in other jurisdictions. Let's make it 50% as suggested by members of our community. Let's let them be truly partners in our community, Madam Speaker. So, Madam Speaker, if that is the case, then I would like to then, and we're saying that, oh, these things are legal right now, then I would then say that the questionable part that, in my opinion, that makes them legal while they're currently illegal, which is Section 7 of the bill, then let's just delete that section. We don't need to amend any other law with regards to whether or not there's a question of this legality, but this amends law that begs the question of whether they're illegal or not. And if we are absolutely convinced that all existing law allows these machines to be legally licensed and operating, then let's not amend any law. Let's be confident that there is enough statutes in place. Let's not add anything else to the statute, Madam Speaker. And so, Madam Speaker, I would like to move that Section 7 of page 14 of the bill be deleted. Because this amends current law, and they're saying, no, we don't need to. Current law already allows these machines to be legal. So therefore, we shouldn't need to amend any law at all affecting these machines because they are already legal and can operate. But somehow this requires an amendment to the law? It shouldn't. And therefore, Section 7 is unnecessary. So I'd like to move that Section 7 be deleted, Madam Speaker.
On the Pangolin Amendment, which is on page 14, to delete Section 7 of the Rodriguez Amendment. Senator Rodriguez, you're recognized.
Thank you very much, Madam Speaker. And Madam Speaker, you know what? I'll take that on. He's right. We don't need to amend it. I want to make an amendment to his amendment that we're going to keep the existing language of law right now, which is on Section 7, line 23. We'll keep it on. That's my amendment. We'll keep that on, and we'll renumber the amendment, the language from 16 to 22. And let me explain why, Madam Speaker. If that is what is being used to provide this misinformation to our people, and you know what? If that's the information that's being used to misguide our people out here in the public hearing room who have been dragged down here for many days, we'll keep it on. Because you know why? I want to explain why this provision is here. These machines that are licensed today, Madam Speaker, that were licensed since 1998. And of course, they had that period when it was in court and they didn't have licenses. They were licensed under this provision. And so, Madam Speaker, we're making it very clear here in this language, is that we're saying these machines that you have licensed already pursuant to this, and pursuant to existing language, Madam Speaker, where it says that only those machines licensed by the Department of Revenue and Taxation as of August 1st, 2001, shall be assessed a licensing fee of $525. The reason why we're doing that, Madam Speaker, is we're saying now we're increasing their fees. And the reason why, Madam Speaker, that we're saying specifically these devices known as Liberty, Symbolics, and Match Play, you know why, Madam Speaker? Because we went to Rev and Tax We said revenue tax, right now existing language in rules or in law says that you must only license and register those machines those machines prior to August 1st, 2001. And I said, what are those machines? So we got information on revenue tax and said, these are the Liberty, these are the Symbolics, these are the Match Play. And so to ensure, Madam Speaker, that we're not opening up the floodgates, as one member of one of these groups that come over here and say that we're opening up the floodgates and off-island people are going to come here and bring in slot machines. We're making it very clear. These are the only ones that are authorized, nothing else, Madam Speaker. These lies, Madam Speaker, must end, must stop. And so I am fine. Leave the existing language in law there today. And my amendment to the amendment is we leave that lines 23, 24, 25, and renumber lines 16 to 22.
Senator, actually, there won't be a need to do that because when you don't touch it, it continues to remain in 11 GCA, Chapter 22, under Section 22202, on imposition where F is there. So it will not delete that at all. That language will remain. It would only be the language, the new F from 16 to 22.
Madam Speaker, point of inquiry.
Please,
Shouldn't we be disposing of the objection prior to moving additional amendments?
No, because you can amend it first, and then that will be the last thing to do then.
So we're doing this
we're still good,
in the
yes.
objection. Okay,
Yes,
thank you, Madam Speaker.
yes.
I just wanted to be clear on that.
Yes. So, do you understand? Do you need a recess?
Or Madam Speaker, and thank you for that clarification, that we can do it where we leave the F there and we just add it. Don't use another number for lines 16 to 22, that after the existing language which says on each video type symbolic amusement machine or any other amusement device that is not listed in the section, $500. If it's going to satisfy people thinking that we are changing it to make things legal, we'll leave that on and just add from line 16 to 22. Continue that on F.
Oh, I think that's not what
That's exactly
Speaker
right,
Pangolin
correct.
was saying.
My amendment is to delete the entire section, Madam Speaker.
And that's why I'm trying to
But by deleting it, that's why I asked if you wanted a recess, because if you look at the code today, F is there. What you just read will be still in law. So by removing it here does not mean that, because what you're doing is that you were trying to delete it and then replace it with a new definition. So when you just remove that,
Madam
F
Speaker, if I may,
continues
on
to
a
be
point of inquiry, based on what you're stating right now, if I can just ask, so if F is deleted and the old F comes in, but F altogether is deleted, that means that there would be no fee to any of those machines that are being licensed today? And that's my question to legal.
Well, if you read F, then
F, on each
if
video
you
type
read-
symbolic
if you read
amusement
the
machine.
if you read the new F, then, and you're saying that there won't be then that assessment, then by deleting it, there won't be an assessment. Vice Speaker.
Point of information, Madam Speaker, if you look at
Please.
line 25, the fee currently is $500.
Yes.
The increase is only going to be 25. So if you just strike the entire 7,
Yes, that's what I'm
that
saying.
line 23 to 25 remains in the statute
Yes.
as it currently stands, and there's a $500 fee.
Yes.
And if anybody's afraid of it, there's also on line 3 the authority given to the commission to impose whatever additional
Yes.
fee schedule it wants.
You
So
are
there's
correct.
already 500,
Yes.
and it's now just we're not getting the additional 25.
You're right.
I doubt the 25 is going to make much difference
And
anyway.
that's exactly what I was saying, is that F in the current law stays. Is there anybody else on the amendment would like to speak on the Pangolin Amendment? Is there any, Senator Respicio, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I rise in opposition to the amendment because if you look at what Section 7 is doing, it provides for the fee to increase from $500 per machine to $525, and then provides a $25 increase in licensing fees to be assessed every year thereafter. And so if the idea is to try to regulate this currently licensed activity and try to increase the revenue collection so that we can have more hospital to GMH, this amendment would just accomplish the opposite. And so I rise in opposition to this amendment, and I ask for our colleagues to recognize that, that what this amendment does, it brings the fees from $500 to $525, then provides for an automatic increase of $25 in licensing fees every year thereafter.
Mr. Vice Speaker, you're recognized.
Madam
Yes,
Speaker,
you registered your objection.
but how many times are members going to be allowed to speak? If every time I say something, someone else is...
No, this is on the amendment.
He already spoke on the amendment.
No, he was a point of information. It wasn't a, yes. So Vice Speaker, you're recognized.
Thank you, Madam Speaker. I'm going to take a point of personal privilege and say I'm not going to participate in the discussion. I don't believe that we should be doing any of this, and so I'm not going to increase it to $10,000 a year like they do in Saipan. If somebody else wants to do that, I've already been called hypocritical for wanting to put any fees at all. So I'm just saying I'm opposed to gambling, period. Whatever the price, I'm opposed to it, you know. So if somebody wants to raise it, that's up to them, but I'm not going to participate in the discussion. I've already stated my objection to any kind of gambling, period.
And I just want to reiterate to everyone is that I don't intend to stifle anyone from speaking. This is too important a subject to try to stifle anyone. And so, Mr. Vice Speaker, you know, you're encouraged as every member of this body, like every member of this body, you know, to give your opinion. And you will be recognized. On the amendment, is there anybody else who would like the opportunity to speak? Well, yes, Senator Respicio registered an objection. Senator, that's what we're discussing, Senator Pangolin's amendment to the amendment. And Senator Rodriguez was the first to speak on it, and he said to clarify it, he had no problem with it. Senator Respicio addressed the body and registered an objection. The Vice Speaker also spoke and basically said is that because someone had questioned the fact that he had spoken before, when what it is, like everyone else, I recognize you for a point of information, a point of objection, a point of inquiry, and that's exactly what the Vice Speaker did, and he was recognized for it. Now, on the amendment, I did recognize him again, and because I guess of that point of personal privilege, you know, he feels that maybe now he shouldn't speak. But I will continue to recognize him like everybody else here who would like to speak on this matter. So those are the three who have spoken on the Pangolin Amendment to the Rodriguez Amendment. Is there anybody else who would like to participate to be recognized? Senator Uggan.
Thank you very much, Madam Speaker. I was under the impression that the good senator, the individual that proffered the primary amendment, made an amendment to Speaker Pangolina's amendment.
Yes.
Is that correct?
Yes.
So what are we discussing right now?
We're discussing Speaker Pangolina's amendment to the Rodriguez Amendment.
So we are discussing the deletion of Section 7.
Yes, the
Completely.
deletion of section.
And was there an amendment by Senator Rodriguez?
Yes. No.
The clerk is saying that he made an amendment, and that's all I'm asking.
One moment, please.
Thank you very much, Madam Speaker.
We're going to take a brief recess. The legislature is back in session. Senator Rodriguez, you recognize.
Thank you, Madam Speaker. Madam Speaker, I move to withdraw my amendment to the amendment.
On the withdrawal of the amendment, no objections, so ordered. So we're back to the Pangolin Amendment, which is the deletion of Section 7 on page 14. And so that's open now for others to participate in that amendment. So is there anybody who would like to speak on the Pangolin Amendment? Senator Respicio.
I just want to register my objections for the same objections I raised to even the amendment to the amendment.
Yes, and I have that recorded as a registered objection. Is there anybody else who have not spoken who would like to speak on the Pangolin Amendment, which is to delete Section 7 on page 14? There being none, then I'm going to ask the author to close on his amendment, and then I'll call for the vote.
Thank you very much, Madam Speaker. Madam Speaker, now I know why. It's absolutely clear to me, with the objection to this amendment being deleted, that there is a concern that gambling machines, electronic gaming machines, are illegal now. And what this bill does is it goes in a roundabout way to legalize them. There is an absolute question of their legality. As a matter of fact, there's a court case right now that says these machines are illegal. They've been in the courts for the last 5 years. And the courts froze all of these machines and says you can't operate them. And as soon as the cases were dropped, all of a sudden they got the governor to convince the Director of Revenue and Taxation and ordered him basically to license the machines. Why? Because of this provision that they're trying to amend. It is only the existence of this provision and the conflict that's created between current law and this provision, the GAR, that gives any hope, I think, for the proponents of gambling, supporters of gambling, to legitimize it. And it is clear to me that the intent of this is to moot that court case. It is to remove this controversy, this conflict in law, from the current laws of Guam that would be smooth and clear sailing for gambling using these video machines. Very clear now, Madam Speaker. Otherwise, nobody would object to deleting this, because then everything is existing in law, and if they're so confident that all the laws that are existing says that these are legal, then why amend it? Why codify this? Why put it in place? It is a roundabout way. And this idea, and now we're going to say, well, you know, you should just eliminate all forms of gambling. I thought we did that. I thought those who didn't want to be hypocritical voted no, that they want gambling, and now they're trying to say, well, I really don't want gambling. I don't support it. I just want to support everything. How can it be like, I don't support gambling, but I want to ensure that all gambling can occur and all gambling is taxed? You can't have it both ways. You either are against it or for it. So to vote that you don't want to wipe out everything and then say, but I'm opposed to it. Madam Speaker, take a look at what this members of sitting in here today. Every single member responded no, that they didn't want gambling in the last. And now we've got a debate on it. I don't understand what's the debate when everybody, when running for election, says, do you support video bingo machines and gambling? No. So what's the debate? Why are we debating that? When we were running for office, we told the people out there who voted 60% no that we didn't want it either. And then now we're debating it? Why don't we just vote no, like we said and told the people that was our position? Are we deceiving them? That now we're trying to cut and distinguish between, saying nonprofit and for-profit? I think that's what the public's telling us. So it's very clear that the supporters of this amendment, Madam Speaker, are pro-gambling, want to do it a roundabout way, trying to resolve a controversy that is in the courts right now that prevents gambling, that will prevent gambling, once the court gets going, and we want to make sure that that court doesn't get going. That's why we can't wait till July 1st, maybe. That's why we deem July 1st is unreasonable, because something might happen in the meantime. It's not unreasonable, Madam Speaker. And by the way, it's unreasonable because we're going to an NCSL meeting and we can't be here after July 1st. That's the reason why we can't stay on the island to do the people's business. Is you can't go to APIL because we got to stay here and do the people's business. But we can't stay on July 1st because we're going to go to to NCSL. People used to go to the junket trip. And now we're saying we can't stay here because we want to go on a junket? That's why we can't wait till July 1st to come back and resolve this issue? Because we're going to go on a junket? Madam Speaker, that's what it is. Madam Speaker, if you have no objections, then clearly you, in my opinion, you would have no objections to deleting this if you fully believe that these machines are currently legal and can operate without any need for any addition to the laws and to amendments as being proposed in this bill. But that is obviously not the case. The original objector said, oh yeah, let's go, let's take it out, because I don't want to be accused of gambling because of this provision. Let's take it out. Then all of a sudden, oh no, let's not take it out. Well, why? I thought initially we said, if this is it, if this is the cause of all the grief we have, then delete it. Well, folks, let's delete it if this is what's causing all the grief with regards to being pro-gambling or not pro-gambling. Then delete it, and then we won't have that argument, and then these machines, under existing laws, can move forward, and we can determine whether or not they're legal. But no, we want to make them legal, and it is this provision that will. And we're doing it a roundabout way, Madam Speaker. And so, without hypocrisy, let's delete this thing. Thank you, Madam Speaker.
You're welcome. There is a registered objection. All then in favor of the Pangolin Amendment, which is to delete Section 7 on page 4. Please raise your hand. 1, 2, 3, 4, 5, 6, 7, and myself 8. It carries. On the Rodriguez amendment, please, is there anyone who would like to speak? Continuing, okay, yes, I do on the list, Senator Tomada. Cancel. Okay, on the amendment, is there anybody else? Okay, I'm sorry, you're right, so you still have the floor.
Madam Speaker, I just want to put on the record. The proponents of this bill said that they want to help the hospital, that the hospital is bleeding and we need to help it. We had resolved the issue of the hospital and its vendor payments, I thought. Maybe not to the desire that each and every member of this body can fully support, because it includes borrowing that some members of this body question whether that's the solution to the hospital's problems. And rightly so, we have a right to question that. But we did. We said that the issue we need to resolve with the hospital is the vendor payments. And once we resolve that, then the hospital can have the ability to manage its finances, stretch out its payments, and so forth. But that we still need to support it. But Madam Speaker, if we're going to do it through gambling, just for the record, I want to put in place, what is the tax on gambling in other jurisdictions that allow it? This bill proposes an additional 4%. So it's only a 4% tax on gambling, because the 4% that currently exists is just for the right of doing business. It's the normal GRT that every other business pays. So what is the gambling tax? It's not 8%, as my good colleagues are arguing. Oh, we're taxing them now at 8. No, we're not. We're only taxing them at 4% because we are taxing them that initial 4% just for the cost of doing business. And if every other business is being taxed at 4. The only additional tax that could be, in my opinion, said a gambling tax or a gaming tax is that incremental 4%. But in Colorado, Madam Speaker, where gambling is legal, the effective tax gaming rate is 13.61%. In Delaware, it is 41.29%. In Florida, it is 37.8%. In Illinois, it is 35.0%, 04%. In Indiana, it is 30.86%. In Iowa, it is 22.80%. In Kansas, it is 27.02%. In Louisiana, it is 24.10%. In Maine, it is 43.45%. In Maryland, the latest one to approve additional casino and racetrack betting is 57.75%. In Michigan, it is 22.57%. In Mississippi, it is 12.12%. In Missouri, it is 26.65%. In Nevada, the first state, I guess they were the first one, so they didn't have any other experience. That's where you find 8%. All the others came later and they saw what the effects are gambling on their community, and they figured they couldn't pay for all of those just based on 8. New Jersey, the second state to have major gambling, was 8.35%. So the only time you have anything below 10% are those that moved very, very early in terms of gambling, because they thought they needed to make it this slow to attract. But the other states found out, nope, at 42%, they're still going to come. In New Mexico, 26%. In New York, 45.65%. In Ohio, 30.72%. In Oklahoma, 18.03%. In Pennsylvania, 47.09%. In Rhode Island, 62.31%. In South Dakota, I think this was the third state that may have gone into any kind of major gambling, 15.48%. And in West Virginia, 42.42%. Madam Speaker, are we really interested in helping the hospital with gambling taxing revenues, or do we just want to ensure that those that have these machines can put them out there at this time with minimal tax? Is it our intent to help the hospital? If it is, and we're going to do it through these gambling and gaming machines, then shouldn't we take a look at all these other rates? Shouldn't we be doing that? But no, what this does is only puts an additional 4%. So it's not really that we're trying to raise money for the hospital, because this activity that we're trying to legitimize and legalize is taxed at a greater percentage. Why? Because these states realize and saw what the effect on society and community that gambling has, and that they can't support the resources and the services needed to help the residents of these communities, who then have to deal with the problems associated with legal gaming activities with a 4% tax or with an 8% tax. They can't afford it. It costs too much money. That's why you see rates such as 43% and 50%, Madam Speaker, 57%. The latest one, Maryland. I've been following the Maryland debate on this thing just to see what occurs. And they realize, they looked at all these other states and all the experiences these states have had, and they say, what is the cost of to our community, and what does it cost us to have this type of activity legally taxed in our community, and how much money do we need from this activity to help our community and to support the services of our government for the people in terms of crime protection, in terms of health care, in terms of social addiction programs. How much does it cost to do all that, and what's the tax that will help us support that if we're going to have it? Certainly not 4%, Madam Speaker. So what should the rate be, Madam Speaker, if we really want to help the hospital? 30%? That is the effective rate across these communities, and maybe that's what it should be. My good friend, one of the doctors, suggests 50%. And look at what look at what Maryland's doing. They're at 57. So maybe 50 is the right number, given the latest experience. The other thing, Madam Speaker, is that in the original bill, Madam Speaker, that said that we were going to tax health insurance on this, in the original Bill 20, did you know, Madam Speaker, that when they proposed that tax on health insurance, that there was a sunset provision that it would stop after we paid off the hospital vendors? That the tax will then be repealed? Madam Speaker, do I see a provision in here, now that it's gambling revenue, to repeal it once we pay off the vendors? No, I don't see it. So if we thought that we shouldn't be taxing our community, and we should only do so to help the hospital, and once we help and pay off those vendors, then we shall remove that tax. But when it comes to gambling, we're going to let it continue forever. There's no sunset provision. So what is the real intention? Why is the intention now changed so that now that we have, when it was tax on health insurance companies, no more tax after we pay off the vendors. But when it's for gambling, no mention at all about repealing the tax once we pay off the vendors. Why? Why the inconsistency? Why the hypocrisy? What is the real motivation for putting this, now allowing gambling through this bill and then putting a tax and saying it's for the hospital? When it was on health insurance and for the hospital, we will stop it. But when it's on gambling, we're going to let it go on forever. Ask yourself that question. The people should ask them that question. Why the inconsistency? Because the real motivation is to legalize gambling and let it go. And they're using the hospital to help make it palatable, to convince the public that we're doing something for the hospital. We're doing this now, Madam Speaker, for an urgent care center. You talk to the staff at the hospital and they're saying, I don't even know if that's going to solve our problem. I talked to the doctors and the medical professionals. Some are saying, yes, you need an urgent care center. But, Madam Speaker, the way this bill does, we're going to fund the urgent care center through this tax. Well, wait a minute. I thought if we open an urgent care center, we would generate revenue from the services provided by the urgent care. And that's how we would fund it. Or else, we would lease out a portion of the urgent care center at the hospital. The management would come in. We would get an income from leasing out the facility for urgent care. These doctors who operate the urgent care would then be responsible for seeing the patients, billing the patients, collecting the payments, and the hospital would make money by renting it out. But no, the way this works is we're going to now pay these doctors to see the patients. When I talk to the people at the hospital, it says, how does that help us? So there's many things. Now we're mandating an urgent care center. We're not, at least that was in the original bill I saw, or the original substitute I saw, that we're going to mandate it, even though the study may come back and say it doesn't make sense. It's not going to help stop the bleeding, but we're going to mandate it. Why? Why are we going to mandate an urgent care center without first finding out what's the economic impact on the hospital and whether or not it's really going to help them financially? It could. I agree. There are ways to make it happen. But we're not even going to debate that issue of how to make it happen. We're just saying we're going to put in an urgent care center, we're going to tax it, we're going to allow a subsidy to that, and then we're going to privatize it. Give it to somebody else. Once more, I kind of look at this. So, Madam Speaker, I just think, and my conclusion here is that it is what it is. There's a difference of opinion between my colleagues and some of us in here on what the effect this bill will do. But given its current position with some of the amendments, then perhaps we can move forward. I'm not sure still. But I also want to ensure that maybe after we do a little bit more study, we'll make a determination at some point in time whether or not we really should increase this 4 to 10 or 20. But as my good colleague says, maybe we'll do that in another bill, subject to a public hearing. Thank you, and Sidusmasi, Madam Speaker.
You're welcome, Senator. Is there anybody who would like to speak on the amendment? Senator Duenas, you're recognized. On the Rodriguez amendment.
That's correct, Madam Speaker. At this point, Madam Speaker, I rise to another concern as I read through thoroughly and understood the Attorney General's primary argument for Bill 19. And that would then, of course, create the conflict as the author of Bill 19 and both of my co-sponsors sat with the AG for days to recraft the Bill 19 to which Bill 20 was now moved into through this amendment. And I address everybody's attention to page 14, section 6, rules and regulations. Madam Speaker, in my simple reading of the rules and regulations that are being proffered in the amendment, these are exactly the rules and regulations that the Attorney General, one portion of their case that's currently in the courts for summary judgment, that they disagree with in terms of how they were promulgated prior. So, Madam Speaker, registering that concern, I would be concerned that we now, through this piece of legislation, should it pass, would once again, and some members believe it is proper codified, but we would recodify that law. So if it really is on the basis of other members, then this is actually redundant. So at this point, Madam Speaker, I move that we delete entire section 6 from line 1 to line 13.
On the amendment, Senator Limtiaco.
Thank you, Madam Speaker. Madam Speaker, as I read this amendment, this is exactly what we go back to. We've already dispensed with whether or not we're legalizing gambling machines by the last speaker of the mover of the amendment, in which we deleted Section 7. And what Section 6 does in this bill is it finally starts getting us down the right path of remaining consistent. And I believe that this basically is saying that if we're going to identify the lottery and the bingo, as well as these symbolics machines, that they should all be, that the Gaming Commission should promulgate rules and regs and fee schedules that are all consistent with this act. And we're finally going down the path of recognizing and removing with the hypocrisy and actually identifying it for the root cause of what it is, and making all of them on par with each other, having parity with it. So, unless we need to get another AG's opinion specifically in writing how this bill affects it, what we're trying to do is just make sure that they're all being identified and rules and regulations are promulgated accordingly for everything. And we can finally start dispensing with some of the hypocrisy that exists and some of the conflicting portions of the law that, under the guise of making them legal, still are the same thing, gambling. Everybody's hiding behind, that's not gambling because it says it's legal in the law. That doesn't go back to the root cause of what I'm trying to say, is that they're all games of chance. So at a very minimum, I think Section 6 tries to establish that, okay, we identify that. Let's all promulgate rules and regulation and fee schedules and taxations that are in accordance with this, so that they're all treated the same. Thank you, Madam Speaker.
Welcome, Senator. On the amendment, Wait, let me get your names down. I have Speaker Pangolin, I have Agun, Vice Speaker. Is there anybody else? Okay. Speaker Pangolin, you're recognized on the Duenas Amendment.
Thank you very much, Madam Speaker. Madam Speaker, the author, I think, is looking at his amendment and so forth. But one of the things I wanted to point out is that I think if this amendment should this amendment should be sustained and should stay in, then I think what we need to do is, I agree with the author, with the retiring speaker, we should start new. Why do we want to put into statute what is questionable at this time? Let that commission then come and take a look at all of these things that are in question legally now with regards to the enactment of the regulations. Wipe those out. Tabula rasa. Let's start brand new, and let's have the Gaming Commission then go, and how are we going to regulate these things? Why do we want to tie then this Gaming Commission to a set of rules and regulations that are questionable with regards to their legality? Remove those and start all over. And so what this does is, no, it doesn't. It ingrains those things. And that those rules and regs that are to be promulgated in the future must include those provisions that legitimize gambling. I say, wipe everything off, no rules and regs, start brand new, and then move forward consistent with the law. But no, what this does is it embeds those things that are questionable that would give clear sailing into the law, and then hamstrings the commission in terms of what it can do then under rule and reg. And so, Madam Speaker, in that respect, I just think that there does need to be a change to this section with regards to allowing the commission to start brand new with rules and regs consistent with what is unquestionably in the statutes and the law at this time. Thank you, Madam Speaker.
You're welcome. Senator Agun, you're recognized on the Duenas Amendment.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to stand in support of the proposed amendment. You know, when we look at comments or recommendations or proposals or concerns expressed by our Chief Legal Counsel, which is the Office of the Attorney General, I've always known this body to refrain to a great extent from enacting legislation that would affect any legal challenges that are in the court, unless in fact it would affect the health, safety, or education of our community. I think that in this case, if you take a look at the proposed amendment by the good sponsors, the deletion of Section 6, perhaps the targeted concern would be on line 8 and 9, which is almost reflective of the language which was just recently adopted by members of this body in deleting Section 7. Because to my understanding is that it is the adjudicated rules and regulations that right now is being contested by the Office of the Attorney General, and the implementation or effectivity of that particular rules and regs. So it really boils down to that section. I agree with one of our colleagues who stood up and said, you know, we need to promulgate rules and regulations. Absolutely. We set the policies, we allow the executive branch agency to be able to go out and promulgate those rules and regulations that would carry out the provisions of that policy. Well, in this case, the way I read it, this section, the lines that I highlighted, such new rules and regulations shall also be consistent with the manner in which existing gaming devices have been legally authorized pursuant to Title 11 Guam Code Annotated and Title 3 Guam Administrative Rules as subsection 7114A5, as well as with the provisions of this act. So, Madam Speaker, have been duly authorized, and then you highlight Title 3 Guam Administrative Rules and Regulations, the exact provision that my understanding is that the Office of the Attorney General is putting into question whether in fact it was properly promulgated. These certainly would reinforce the concern of the sponsor of the proposed amendment to delete Section 6. So I stand in full support of his amendment. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, Mr. Vice Speaker.
Thank you very much, Madam Speaker. And I I agree with the last speaker, except that I really do think that if one reads very carefully what is in line 6 to 8, again, it does what one of the previous speakers has said. Legitimizes something that is currently in litigation. It goes, such new rules and regulations shall also be consistent with the manner in which existing gaming machines have been legally authorized pursuant to Title 11 Guam Code Annotated 22202F and Title 3 Guam Administrative Rules 7 4A, as well as with the provisions of this act. If we want to give the Commission authorization to do rules, then I think paragraph 1 and paragraph 3 should be sufficient. 2, canon should be deleted in its entirety. And at some point, when it's appropriate, I'll move that any reference to Title 3 GAR 7 be deleted from the bill so that we leave it completely clean and let the Commission deal with the rules that it's going to write within 180 days without being hamstrung by rules that the compiler has waved red flags at us and said she has questions with it, and the Attorney General has issued an opinion to you, Madam Speaker, and to, I guess he has to John Camacho, though John couldn't share it with us, but the Attorney General says the opinion that he issued to you is that Title 3 GAR 7 are questionable. And I just, as long as we're just on this section, I think that the deletion canon should be limited to just lines 6 to 9.
On the Dueñas Amendment, Senator Spicer, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I rise to an objection to deleting Section 6, and also in anticipation of the succeeding amendment, I rise to an objection to that as well. Madam Section 6 provides for some consistency, as a previous speaker pointed out, that if we're going to recognize that these type of gaming activities exist, the current law provides the Guam Gaming Commission to develop the rules and regs on how to tax these legally licensed activities. And so in further looking at line 6 through 9, Madam Speaker, it provides for a manner to be consistent with what this Bill 19 as amended, should this amended pass, what this Bill 19 as amended provides, that if there's going to be a 4% assessment on these legally licensed machines, then we don't want to leave it open-ended for the Guam Gaming Commission to now go and tax other type of activities a different assessment fee, at 20%, 30%, 40%, whatever the case may be. And so going back to question Title III of the GAR and the manner in which that was adopted, that's for the courts to decide. We were in session in the Committee of the Whole where we heard from opposing counsels, and you did say so yourself, Madam Speaker, that if you have 9 attorneys in a room, you get 9 different opinions. And it was the opinion of the Governor's Legal Counsel that what provided for the legalization of these machines was Public Law 26-65, I believe, that authorized, notwithstanding any provision of law, the Department of Revenue and Taxation to provide for these rules and regs. And they did the rules and regs, they submitted it to the legislature. You know, those of us in the 27th legislature didn't recognize any red flags or any problems, didn't take any action to remove those rules and regs, and so after 90 days, they were duly promulgated. Now, if the Attorney General believes otherwise, then the Attorney General is rightfully so taking this matter to the courts. Now, I don't support deleting this section, because if we delete this section, Madam Speaker, then how are we going to provide for a level playing field with other types of industries, like the nonprofit bingos, like the GNOC, which was a matter before this body on the original Bill 19. And so if we're saying these machines that were licensed pursuant to Title 11 of the GCA and Title 3 of the GAR We're not saying that Title III Administrative Rules and Regulations is hereby codified or adopted. I mean, there was, so we're just saying that these rules and regs have to be consistent with what we're doing here in this bill. And so if we remove any references to that and we delete Section 6 in its entirety, colleagues, we're going to be providing for an unleveled playing field and providing for this Guam Gaming Commission to just assess these fees at will. And so I'm asking that we don't support the amendment, and I'm asking that we provide for consistency. And in order to provide that consistency, Madam Speaker, we have to attach it to something. And so what we're attaching it to was the manner in which these machines have been legally licensed, not once but twice. So I stand in full opposition to deleting Section 6, as well as any attempts to delete lines 6 and 9 of the same section. Thank you, Madam Speaker.
On the Dueñas Amendment, which is in page 14, Section 6, to delete Section 6, Senator Nicholas, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I'm confused in some things. I mean, here we are, we're trying to tax activities that have been licensed. And those of us who want to tax those activities that have been licensed are being called pro-gambling. I think the ones who are pro-gambling are the ones who don't want to raise their taxes. If you don't want to raise the taxes, if you don't want to create a fee structure, if you want to take them out entirely from the law and kind of let them continue operating in the Wild West environment that they are, you've got to be the one supporting gambling. Now, there's a challenge to these machines because of inconsistencies in the code and the rules and regulations. Or at least that's what the challenge is based on. So it's important for us to make sure that if we're going to be taxing these devices, raising the taxes on these devices, we don't tinker at all with what's existing in the code and in the rules, because if we tinker with that at all, then we're going to be even furthering the cause of gambling. And so what this section does, Madam Speaker, is it says that is going to stay consistent. We're not going to tinker with that. Let the courts figure that out, which is where it should be figured out. We're going to keep that consistent. And on top of that, we're going to make sure that we raise the taxes on those devices. Surely the ones who want to keep the taxes lower and not keep things consistent are the ones who support gambling. If those are the extrapolations that want to be thrown out there with this body. Now, I don't support gambling. I want to raise the taxes on these devices that have licenses. I want to make sure that we're as consistent as possible in how we're doing it, so that we're not going to throw the case one way or the other. And that's exactly what this section does. That's what this whole amendment does. And to confuse it otherwise is trying to create yourself to be some false hero. Let's raise the taxes on these devices. Let's get the money to the hospital. Let's keep it consistent so that it doesn't get confused into courts while they resolve it. And let's quit pretending that it's something else. Thank you, Madam Speaker.
You're welcome, Senator. On the Dueñas Amendment, is there anyone else who would like to speak? Senator Rodriguez, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I too rise in objection to the amendment. you know, we're here talking about these rules and regs that were promulgated, and I'm really confused because, I mean, now we're talking a lot about inconsistencies and hypocrisy. Madam Speaker, it was this body that ordered Rev Tax to promulgate these rules. As a matter of fact, one of those members are members of this body today who ordered Rev Tax to promulgate those rules, Public Law 26-52. And it was that law, Madam Speaker, that created that monopoly. They said that my bill is creating the monopoly. Read the law, Public Law 2652. Section 4, notwithstanding any other provisions of law, the Cockpit License Board, together with the Department of Revenue and Taxation, is hereby authorized to promulgate necessary rules and regulations to create a comprehensive regulatory scheme to regulate all gaming activities on Guam, provided that the rules and regulations shall restrict gaming activities to those authorized and licensed on Guam as of August 1st, 2001. So, Madam Speaker, we're not creating any monopoly. This was created already. And so I object to that, to the amendment.
On the amendment, is there anybody else before I call the mover of the amendment to close? Senator Duenas, you're recognized.
Madam Speaker, I have heard on Saturday and now I heard today, I am confused. And now I am confused. Madam Speaker, the retiring speaker from Talafulfo via Derido and others that have rose to object to this amendment clearly are not confident, including the immediate retiring speaker, that the rules and regulations were promulgated properly. Because, Madam Speaker, all of those rules and regulations which my team and I went through exhaustively in the original version of Bill 19 have everything that's being discussed within this section of the amendment, Madam Speaker. This is the crux of the Attorney General's case. So if those who are confused on the floor and say that this deletion is going to open the floodgates and create all this mayhem because now there's no control, well, then they're affirming the fact that they believe that there's validity to the rules and regulations having not been promulgated. Madam Speaker, it is in the rules and regulations that all the quotations that have just been put forward, it is there in which lies the ability to tax limited gaming. If we want to stop talking about gambling and we want to stop being confused about gaming and we want to talk about taxes, that's where the taxes are, Madam Speaker. So at best, this proposal in the amendment is redundant. So I am offended. I'm offended at the assertion that after having gone through all this time with my co-sponsors, having worked side by side with the Attorney General, and it's one of the reasons why I continue to object for putting Bill 20 and 19. Argue your bill, stand alone. But Madam Speaker, please, I know we throw things out on this floor, but let's be fair. If you're confident that the rules and regulations were promulgated properly, and if we don't want to talk about gambling, we don't want to talk about gaming, we want to talk about taxation, we want to talk about consistency, we want to talk about the fact that we're not hypocrites, then you don't need to be redundant. If the rules and regulations are promulgated properly, then everything is in place to tax gaming, limited gaming. The reason why the Attorney General, in their explanation, Madam Speaker, is opposed to the promulgated rules and regulations is not because of tax. And it's not because of the rules and regulations to regulate limited gaming. The reason why they're opposed to it, Madam Speaker, is because of the section in there that legalizes the machines. That's the crux of their case. So I'm offended that anyone would stand up and say that, you know, to remove this is to go to the wild, wild west and open the doors and do all these things. Then, Madam Speaker, I declare on this floor at this point then that there is no confidence for the movers of their legislation, of Bill 20, and those who believe that those machines are legal, then they have no confidence then that the rules and regulations were promulgated properly, that they need to be redundant and put it in this amendment. Madam Speaker, I call for the vote, and I hope this body can vote to remove redundancy within this amendment. Call it for what it is.
There are, of course, objections to the Dueñas Amendment, which is on page 14, to delete section 6 in its entirety, which is from line 1 to line 13. All then in favor of the Dueñas Amendment to delete, please raise your hand. 3, 4, 5, 6, 7. 2, 3, 4, 5, 6. How many did you count? No. 1, 2, 3, 4, 5, 6, 7. I'm 7. So so it's 1, 2, 3, 4, 5, 6, 7. So the amendment fell. On the Rodriguez Amendment, trying to see who I have on the list. Is there anybody who would like to speak on the Rodriguez Amendment? Anybody else? There being none? I'm sorry, if I speak, I don't understand. I mean, I saw. As I stated earlier, I realize that, Senator. Because as I said earlier, that this is too important a subject for me to not allow members to speak. And I've done this before. So is there anybody else who would like to speak? I know originally I had Senator Ada, but you had decided not to on the main motion, on the main amendment on the amendment, the Rodriguez Amendment. Well, there's the discussion is those in favor and those who are objecting. So Senator Ada. Yeah, soon. Senator Ada.
I just wanted to take this opportunity to, I guess, before we finally send this bill down to the third reading file, and then, I mean, to the voting file, and then to cast our votes on it. But I think that there's been cogent arguments that have been made that while the bill, while this amendment certainly does not legalize, or for that matter, Bill 19 does not legalize gambling, we got to recognize that they're already they exist, they are licensed, and we should at least try to at least tax them to gain some benefit out of it. And on the issue of whether we should just eliminate it outright or to further corral it so that it has tighter parameters to operate within, that is a separate question. And I think that some of the arguments that have been proffered certainly are very, very logical and very cogent. I personally do not support putting this amendment on Bill 19, nor do I support Bill 19, simply because of the fact that I think that even if we're saying that we're not legalizing gambling, and even though we don't support that gambling, we're going to try and squeeze some sweetness out of it. And my objection is that when we do that, then in effect what it would do is really, it would blunt the sting of the controversies that's surrounding the gambling activities on our island. Right now you basically have the people who are saying, we don't support gambling, and by now being able to tax it so that we can get some good out of it, then what it basically is going to do is it's going to take those heads and just kind of turn it a little bit away from the gambling activities that is very controversial. And so I know that yesterday I indicated that our world is not so black and white, that either you allow gambling or you don't allow gambling, and that there's those shades of gray, and that we probably need to put in the necessary amendments to get those parameters in place that will corral this activity to at least mitigate some of the social ills that many of us believe are associated with gambling. And so I don't believe that a lot of those mitigating parameters are in this, and I don't know that we can do it on the floor. And so because of that, I certainly cannot support putting the basically Bill 20 as a rider on to Bill 19, nor do I support Bill 19 for that matter. Thank you, Madam Speaker.
Welcome, Senator Ada. So if there is no one else to speak, then I will recognize then the mover of this amendment, Senator Rodriguez, to close.
Thank you, Madam Speaker. Madam Speaker, I call for the question.
Okay. There are objections, so I'm going to call then for the vote to place. You have to remember now is that we're back to the original amendment, which is to place the amendment, yes, as amended, to Bill 19, the Rodriguez Amendment. With, well, it's Rodriguez, Tony Ada, Respicio, Munya Barnes, San Nicolas, McCready, Yamashita, and Limchaco. This amendment to be placed in Bill 19 as amended. All in favor, please raise your hand. 1, 2, 3, 4. 1, 2, 3, 4, 5, 6, 7. Can you please count? Count for me. There are 9, so the amendment then carries. So Bill 19 as amended. That's the main motion now. 9. The clerks counted 9.
It was 7.
Can I see?
No, it was 7.
Okay, I'm going to read then what the clerk has Senator Tommy Morrison, Senator Michael, okay, so we're going to do a roll call. Roll call then on the amendment as amended. Sorry, Senator Morrison, you were right in the front.
Senator Tom Ada. Senator Tom Ada, nay. Senator Tony Ada. Senator Tony Ada, aye. Senator Uggan. Senator Uggan, nay. Vice Speaker Cruz. Vice Speaker Cruz, nay. Senator Duenas. Senator Duenas, nay. Senator Limtiaco. Senator Limtiaco, aye. Senator McCready. Senator McCready, aye. Senator Morrison. Senator Morrison, nay. Senator Munya Barnes. Senator Munya Barnes, aye. Senator Pangolin. Senator Pangolin, nay. Senator Respicio. Senator Respicio, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator San Nicolas. Yes. Senator San Nicolas, aye. Speaker Wampat.
No?
Speaker Wampat, nay. Senator Yamashita. Yes. Senator Yamashita, aye.
The Dwayne Rodriguez's amendment has 8 yea votes, 7 nay votes. The amendment carries. On the main motion, which is Senator Duenas' Bill 19 that has been amended, are there anyone who would like to speak now on the amended version of Bill 19? On Bill 19, so. It's all over because it's been amended now, so. Maybe we should take a lunch break. State your point of order.
Madam Speaker, thank you for recognizing me for a point of order. We heard from the author of Bill 19 that he may indicate his desire to withdraw the bill. Madam Speaker, I want to make sure that, again, they don't take advantage of the procedures and bring us down this road.
Excuse me, taking advantage of what procedures?
Well, I'm asking for a point of order because I recognize that the rules allow the author of the bill to withdraw the bill at any part of the process. I'm asking that the sponsor indicate whether or not he's going to withdraw the bill because I'm concerned, Madam Speaker, that we're going to continue to discuss Bill 19 now as amended. If that's put on the voting file, then can he then withdraw the bill right before we're going to vote? I want to ask at what point does it remain collegial for him to have the authority to withdraw the bill pursuant to our rules, and maybe you can ask the legal counsel for her opinion. I just don't want him withdrawing the bill right when the bill's in the voting file, or withdrawing the bill after the bill passes.
I think, Senator, the only one who can answer that question would be the author of the bill.
Madam Speaker, in reference to collegiality, we have been here now for 2 days. I have registered time and time again my objection to commingling these bills. I would at least like, now that this bill has been forcibly amended, to be on the floor for discussion, and I would reserve that right in my closing. That's the least amount of collegiality that this body could give me, is to allow me, just like every other member, Madam Speaker, to withdraw a bill upon closing. There's still arguments to be made on the forcibly amended version of this bill. And Madam Speaker, I believe that that is the most collegial thing that we could do, not to force a member to have to force his hand without the ability to at least close on his or her bill. I'm offended by that.
Madam Speaker, I certainly recognize his right, but I think what would be more offensive to this body, certainly he can withdraw upon closing, but if he was going to withdraw his bill right before we were going to vote, then I don't know if that's being collegial.
Point of order, Madam Speaker.
Please state, one moment, please state.
I
your
thought there
point
was
of
a
order.
question to rule on a point of order on when the author can withdraw his bill, and I think that we should just take a look at the standing rule, so at least you can tell us when in that standing rule. And I think
Yeah.
it'll be pretty clear that
Yeah.
he can draw it at any time he wants.
That's correct, and so recognizing he has that authority under our rules, I'm asking the sponsor to continue to be collegial and not, and once the bill moves to the third reading file with all the amendments intact, that he not withdraw the bill minutes before we're going to vote on the bill. And so that's what I'm asking for purposes of transparency.
Madam Speaker,
Yes, Senator.
point of information. You intend to call for the vote on all legislation as engrossed, right? We're not voting on one bill at a time, right? So Madam Speaker, for the record, in response to collegiality, absolutely, Madam Speaker, it's my absolute commitment to not go to the voting file and withdraw my bill at that point. I will withdraw my bill after my closing when I have determined whether or not that it's suitable to stay on as the author, and in respect to my co-sponsors, who I know one is completely objectionable to even 20, and was gracious enough to be on 19. I have to respect those people too, Madam Speaker.
And for the record, yes, you will then be allowed to close after all discussions have been made on Bill 19 that has been amended. I would also like to state that just last week, when Bill 100 was in the voting file, that I have pulled my bill out of the voting file even after we've deliberated and sent the bill down. So with that, we're going to take a recess and be here at 2 o'clock this afternoon, lunch recess.